connection's being a little funny here.
We might just go ahead. I'm going to go ahead and
Okay.
you can just work on it.
It's fine with me.
All right, guys, we are in the studio with the deep dive on Murphy today. In the studio, we have Angel Ellis, who is currently working on getting our links up to Facebook and Twitter. And we have Judge Patrick Moore, who is going to be our legal authority in this matter. He has legal experience spanning decades at the tribe. He was the district court judge in the Muskogee Creek Nation for 25 years. He has also been a prosecutor, the DA in Okmulgee County, and he was consulted on this case. So thanks so much for coming in. He also happens to be my dad, so I appreciate him coming in and helping me out on this deal. To get us started off, Dad, could you kind of give us the history of how you became involved in the Murphy case and what your understanding of it is, and as much information as you want to give us?
Well, the Murphy case was started by the district attorney's office in Okmulgee County because they had jurisdiction over McIntosh County. As I remember, this was a long time ago, but Tom Giuliani was the district attorney, Rob Barris was the prosecutor for McIntosh County, and I was asked to come down and visit with them on several occasions with respect to whether there was any problem with Indian country down in McIntosh County. At that time, as I remember it, the activity that they were prosecuting someone for occurred on a section line, and as I remember, a body was moved into the ditch and rather stomped and what have you. And then when that was completed, the persons involved in it left to go find the man's son who they had stomped and killed, actually, so they could eliminate him also. And that's how they got apprehended. They were caught going to this man's house, as I remember it. The issue was whether the property that they were on was restricted Indian land. And by restricted Indian land, it wasn't land of the Creek Nation, it was an allotment. And allotments are different than lands that are Creek Nation lands in that they have been conveyed to somebody in fee simple. Now that doesn't mean that they weren't Indian country under the new law.
The new law being the 1948
Well,
Major
the
Indian
Indians,
Crimes Act?
yeah, well, the Indian Civil Rights Act comes into play in the
Okay.
Major Crimes Act. Major Crimes Act was enacted, as I remember, because there were some. The federal government doesn't have all the crimes that states do, and so they needed to bring in some major crimes, and they did that with the Major Crimes Act, and it's grown by other crimes have been added.
Can you stop
Excuse me.
on
Sure.
on allotment and the difference between allotment and
Well,
tribal held
allotments
land.
aren't the property of the United States. They're the property of the Indian. And the Indian got his allotment by a fee simple deed from the principal chief of the Creek Nation.
Okay.
And that's a big difference. And everybody's missing these big differences. And they're important big differences. But the Major Crimes Act and the new law where they say these communities, just because there's a predominance of Indians in a housing development out in the countryside, can become Indian country, all of those changed since statehood and since Indians got their allotments and what have you. And really, Indian nations are 5 tribes, Indian nations. have misconstrued a lot of the property interests that the federal government has and the Indian tribe has in property. They like to call everything Indian country, but the only way it's Indian country is if the allottee is still restricted. If the allottee has had children, now that's prior to the recent Stigler Act amendments, if the Indian had children and the children had their blood was less than one half, that land is no longer restricted. So Creek Nation had no jurisdiction over it just by operation of a marriage.
Right. And that's the argument of the state, and this for the state jurisdiction in certain areas.
Well,
Right.
That could have something to do with this case because, as I remember, the only
Do
restrict.
you need to go change it? Angel's going to run out, and she's going to do some alterations to it, or alterations to a story we've got going. So.
You want me to stop?
No, you're good. We're going to continue.
There
Well,
were-
speaking of that, let me just interject really quick. While we're talking about the case. So after you were consulted, and then we saw what happened next in the Murphy case.
Well, they went ahead and tried the lawsuit
Okay, and you're talking about in the
in
district
McIntosh
court.
County
Okay.
District Court.
And then it went up from there to.
They got a conviction, and of course, it was I think it's a death penalty case. Isn't that correct?
I believe.
Okay, so there's there's an appeal on that,
Right.
and it was appealed, and the appeal wasn't successful for Murphy. And this was back in the 90s, I want to say. Do you have the exact date of when Murphy was tried in state court down in McIntosh County?
I do not have that, but I can look
Well, it'll
at
be
that.
it'll be in the records someplace.
Well, what I'm concerned with here is let's move forward. Eventually, this case got to the Supreme Court level, and how did that happen? What from your standpoint?
Well, all these appeals were gone through, and they ended up in the 10th Circuit Court of Appeals. And a 3-judge panel of the judges in Denver invoked a case called Solemn, which did involve a reservation, and said that this property the property where he was an Indian reservation. And then from there on, it's going up to the Supreme Court of the United States.
Well, and the argument there would be that because it has reservation status, then the only things that would have jurisdiction there would be the federal government or the tribal government, right? And so when the state conducted his arrest and everything, that they didn't have the jurisdiction to do those things, right?
That's what the allegations are.
Okay. Let's take a look.
There's another problem with that. As I remember, this land that was adjacent to that section line, there was 1/12 or 1/16 of the minerals was the only thing restricted.
Okay.
And the minerals aren't on the surface.
Mm-hmm.
They're thousands of feet down into the, and if 1/12 is enough, that was just old restricted property inherited by no telling how many people, and it could or could not have been restricted at that time, depending upon who had it.
And if we look at what we have up right now on the screen about, which is the actual question presented before the Supreme Court, right? The question that ended up getting presented to the Supreme Court is whether the 1866 territorial boundaries of the Creek Nation within the former Indian Territory of eastern Oklahoma constitute an Indian reservation today under 18 U.S.C. 1151A, and then the 171107 is the Murphy case number. So that we can understand the distinction that you're making about the restricted status of the property. The Murphy's lawyers aren't actually arguing about the restricted status. They're saying that because they believe that it is a reservation, it qualifies under 18 U.S.C. 1151A. Let's go and kind of explain to the audience what 18 U.S.C. 1151A is. So I'm going to bring up, let's see here, where is this? It's not there. No. Here. So the 18 USC 1151 is the Indian Major Crimes Act that was passed in 1948 that gave a definition of the jurisdictional definition of Indian country, which is except as otherwise provided in sections 1154 and 1156 of this title, the term Indian country as used in this chapter means A, and this is the A that is in the question on the Murphy case, all land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent and including rights of way running through the reservation. Now I'm going to mention a couple other things before we talk about that. But what I wanted to mention too, in addition, was the B and the C. So B is all, there's other qualifications. B, all dependent Indian communities within the borders of the United States, whether within the original or subsequently acquired territory thereof, and whether within or without the limits of a state. And C, all Indian allotments, the Indian titles to which have not been extinguished, including rights of way running through the same. Now, I wanted to mention those because this Indian country definition in Murphy is being challenged under the A, reservation status, right? But other people that want to get their judgments or want to challenge their convictions on jurisdictional things could also choose B and C, right? That, like, there's not just A. In the Murphy case in particular, it's A, but there's also these other qualifications. And here in a minute, there's an article I want to read some excerpts from that will kind of touch on the history of where did this A, B, and C come from for the 1948 law. But before we go there, all land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding issuance of any patent and including rights of way running through the reservation. How do you classify a reservation? First off, let's talk about that a little bit, because that's one of the things that I don't understand in the case is, to my understanding, I'm not a lawyer, but reservation status would say that the federal government is holding lands in reserve for a tribal use or tribal government, right? And that they own the land. And let's talk a little bit about who owns the land at the Creek Nation, this 1866 boundaries that's referred to. What are those?
The 1866 boundaries are the boundaries of the land after the Civil War that the Creek Nation retained when the federal government made them convey lands west of, I'm going to say, the Creek County, Seminole County borders out to the Panhandle. That was originally Creek Nation land. And after the Civil War, the United States came in, and Abraham Lincoln had promised a group of politicians, political people who were called free soilers, that if they would support him to become president, he'd see that they had land out in the western part of the United States. And it was just easy after a Civil War to go in and tell a Indian tribe that you messed up and you violated your treaty with us, and therefore we're going to punish you by taking half of your land. And that's what they in effect did. There's some question as to whether or not that land was actually legally surrendered and signed, the deed signed by Obithiahola, who was dying in Kansas because agents from the Bureau of Indian Affairs came to his bedside in Kansas and told him that the federal government was going to have to punish the Creek Nation by taking their lands from in western Oklahoma back to the roughly the county limit of Creek County and Seminole County. And when they did that, they told Obithiahola, but we can't represent you, Obithiahola. That would be a conflict of interest for us to represent you, but we have a friend from Washington who's going to represent you in this and make sure everything is legal. Heirs and relatives of Obithiahola dispute he signed anything. And so, but they went ahead with it, and then of course that land was then conveyed back to the United States by fee deed.
And we're talking about lands in Alabama or Georgia?
No, we're talking about land in western Oklahoma.
Oh, in Oklahoma, okay.
We've been out of Alabama for a long time.
Well, it was my understanding that the land that was that the tribe received the fee simple deed for lands in Oklahoma.
That was to pay them for land they had in Georgia.
Right. Okay. So was that after the Civil War? Before
No, that was in 1830s, 1825, 1830s.
Okay. So
the deed was written in 1854.
Right, because I had read that that situation was that there were white settlers that had come into those lands, and that the tribe wanted the federal government to go in and remove those settlers. And the federal government said, we're not gonna send troops down and remove the settlers.
No, because the settlers voted and the Indians didn't.
Right, and so they said, we will give you something of equal value in the Indian territory.
Acre for acre.
Okay, so the situation of the 1866 boundaries that was land that the federal government actually gave the deed to the tribe as a way to make them even for the lands that were lost.
To get them out of Georgia and Alabama.
Okay, so in that situation.
But then after the Civil War, they needed some more land for some guys that supported the president.
I see.
So we'll go get the 5 tribes. They own Oklahoma from the Arkansas to Texas.
I see.
And we need that land so we can have a land rush. And the Sooners came in after they got the land back. They took it from all the.
Was that land purchased, or how did that transaction?
They took it by war.
So
they took it as a war punishment.
Oh, so it
was punishment for the Creek Nation and the chicken.
Is that
do what now?
The tribe ceded the land. Is that
they gave a deed according to what the records reflect.
I see.
The
and
principal
that's what you're
chief
saying.
at that time of the Creek Nation was Obithiahola, one of them.
And that's the disputed that he signed it.
Well, that's just what history tells us. He died in Kansas. He never got home.
Gotcha. Okay.
His ranch was down by Henrietta.
All right. So, so in your mind, or is it possible, how is it a reservation if the tribe owned the deed? Is there
another? It isn't a reservation.
Okay.
Reservation's owned by the federal government.
Okay, that was my question.
That's the difference between. If the federal government owns it, then they reserve it for the Navajos.
So with that question, we also have the McGirt case that has been granted certiorari at the Supreme Court that is related to this. I wanted to pop that question up and see what the difference is. So in this situation that we're going to get back to this point about the reservation a little later when we talk about Justice Roberts asking for some more clarifications from all the parties in December of 2018. But right now I wanted to touch on McGirt because the question before the court in the McGirt case, which is also a case where you have an individual who is saying that the state didn't have jurisdiction in my case. The question there is whether the Oklahoma courts can continue to unlawfully exercise under state law criminal jurisdiction as a justicable matter in Indian country over Indians accused of major crimes enumerated under the Indian Major Crimes Act, which are under exclusive federal jurisdiction. So there is some legalese there. I was wondering if you could parse that for me. What is that question actually asking?
Well, the federal government has jurisdiction over some properties in eastern Oklahoma that were part of the original Creek Nation's deed, no doubt.
Okay.
They kept some of. There's forts and other things and post offices and federal buildings in eastern Oklahoma that are part of the United States government's land base. But to come in many, many years later, over 100 years later, and say, well, we really didn't, you had a fee simple deed, but it doesn't really mean anything, that's bunk.
Well, my question here is this justicable matter. What is that referring to? What is it saying? Is it saying the court can't hear these cases until Murphy is solved, or what?
Well, they're right now, it's in limbo as to whether the courts of Oklahoma are going to be able to handle crimes that are committed right out here on Highway 75,
Okay.
or crimes that are committed in downtown Okmulgee.
So the question here is that what the question before the court would be, is if Oklahoma under state law can continue to exercise prosecute cases?
And they can, in my opinion, this is my opinion, because the land passed from Indians a long time ago.
Right. So, but that's what this question is. That's
the way I look
for
at
McGirt.
it.
Okay. So they're asking that if the Supreme Court has granted cert on McGirt, what does that say about the Murphy case from that perspective?
Well, McGirt doesn't tell us anywhere in his briefs that he filed for certiorari and they granted it on actually what the land title was and the property where these alleged crimes took place in Wagoner or Broken Arrow. But there are some important things in the McGirt case that nobody says anything about. One of them is Article 6 of the Constitution and laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and judges in every state shall be bound thereby. The United States Supreme Court is supreme to Title 18. It's the
Okay.
Constitution. And the Constitution controls whether something is a reservation or a fee simple patent. Okay?
All right, I've got McGirt's filing here. Let's take. You want to go in and take a look at it? See
Go
what
to
he says?
page 2, or at the second paragraph, indentation down.
All right, let's see here. You
Keep
want to
going.
go in down here. Jurisdiction. This where you want?
No, what? You page 2?
This I don't know what page is. Page
Don't-
1,
don't
page
move
2.
it so fast.
Here we go. Page 2.
Slow down.
Where
a
do you
little
want
bit.
to start?
Right there where it says Article 6 of the Constitution.
Okay. Article 6. This constitutional laws of the United States shall be made in pursuance thereof, and all treaties made. And this is McGirt's filing, so he's
But that's what the Constitution says.
right. Okay. So
It says all treaties made.
right. So he's saying that
All
because-
treaties made are the supreme law of the land.
yes, because the 1866 treaty, or the treaty that gave the land to
And that was done back in the 1820s and 1830s, and the deed was given to the principal chief of the Creek Nation in 1854. Willard Fillmore was the president. He signed a deed.
okay.
They'd been promised it numerous times, and finally they got a deed.
Okay.
You've got copies of it, don't you?
I'm going to jump ahead here. Let me where did it go? And go to the article that I referenced earlier, because at this stage we are in a position where we could go. I found this article while I was doing research on this, and I've been doing research on this since Murphy, before even it became a news thing. This article, Revisionist History of Indian Country. Now, I don't agree with all of the conclusions, etc., but the reason I wanted to read some passages from this is because this gentleman, in the process of getting to where he can state his thesis and give his arguments, he has to give a history of the term Indian country. I'm not going to read the entire history that's in this article, but if you're interested in that, go through it. And I wanted to show that this was published in the Alaskan Law Review in 1997. This gentleman is law clerk to Judge William C. Canby. And do you want to tell the audience what you know about Judge Canby?
Judge Canby is an authority on American Indian law, and
All
a
right.
justice and a justice of the Court of Appeals for the Ninth Circuit.
Okay, so we can assume that this gentleman that wrote this, Joseph D. Mattal, he's not just some crackpot, right?
Oh, he works for
Okay.
somebody who knows what they're talking about.
Now I'm going to read this little thing right here. This article argues tribal sovereignty, yada yada. I'm not really concerned with his arguments. If you want to read his whole arguments and the whole article, which is very long, the link is in the informational description on the video, so you can click that and go through it. I do want to go and read a passage, because what the gentleman does is the early parts of the article are describing the term Indian country, how it's been applied historically from before there was even the United States, when there was the colonies, and on up through when the tribes were moved to Indian Territory, and also when they later got enveloped in the states. But for our purposes, because both McGirt and Murphy are centered around 18 USC 1151A, right? That definition of Indian country, which we read earlier, I wanted to go and read this gentleman's historical association of how they came up with that A, B, and C that is in that Indian Major Crimes Act. I'm going to start here at this Hallwell's construction and go through, and he breaks it into pieces for each A, B, and C. So I'll read that section for A. We can have a discussion about it if you think it's accurate or what the implications are, and then we'll go to B and so on. So Hallwell's construction was reaffirmed in Donnelly versus United States. That case held that the federal criminal laws for Indian country extend to a murder on an Indian reservation, even if it is under state jurisdiction. Donnelly made clear that there is no requirement that the United States have sole and exclusive jurisdiction over Indian country. The court acknowledged that it was modifying the meaning of that term, which was still employed in the criminal and liquor laws, but had not been redefined by Congress in 80 years. The sovereign tribal territory was quickly disappearing as reservations across the nation were allotted and subjected to state law. Had the court continued to define Indian country in jurisdictional terms, it effectively would have repealed these statutes. There soon would have to be no such, quote, Indian country, unquote. The need to disconnect Indian country from sovereignty was presented by the facts of Donnelly. The murder at issue had occurred on an extension that had been added to the Hoopa Valley Reservation in California by an executive order in 1891. This is the same reservation examined in Kagama, which is another case, where the court had struggled with a rationale for federal police authority in the absence of exclusive federal jurisdiction. California never had made a jurisdictional cession over Indian lands, and in any event, it was beyond dispute that an executive order setting aside land within a state did not divest the state of its jurisdiction. In Kagama, federal criminal jurisdiction had been upheld under the Major Crimes Act, which applies to all crimes by Indians on reservations, regardless of state jurisdiction. However, in Donnelly, although the victim was an Indian, the murder had been committed by a white. The only possible basis for federal jurisdiction was the Indian Country Crimes Act, which since 1817 had extended federal laws to all offenses in Indian country. Had the court continued to define Indian country as outside of any state's jurisdiction, the federal government would have been unable to punish a white for murdering an Indian on a federal Indian reservation. The court opted to update the definition of Indian country. It decided to consider, quote, the changes which had taken place in our situation with a view of determining from time to time what must be regarded as Indian country where it is spoken of in statutes, end quote. Donnelly explicitly severed Indian country from original Indian sovereignty. The court declared, quote, the term cannot now be confined to land formerly held by the Indians and to which their title remains unextinguished, end quote. Donnelly considered which Indians Congress intended to bring within its laws and what areas should fall within the protective sweep of Indian country. In a first step towards a new definition, the opinion determined that, quote, nothing can more appropriately be deemed Indian country than a tract of land that is lawfully set apart as an Indian reservation, end quote. Today, Donnelly forms the basis of subsection A of 18 USC 1151. So, what are your comments on that?
Well, they're all talking about reservations. They're not talking about a fee simple deed.
Right.
There's a difference between a reservation and a fee simple deed.
Right, but it also discusses that the land has come out of Indian hands. They don't have the deed anymore. So,
Well, that doesn't make any difference. They can't. An Indian tribe can't convey land that's in the reservation status. The federal government has to.
okay, let's move to B, the other qualifications. The court's next two Indian country decisions were also codified in 18 USC 1151, but they are less interesting because they only involved areas that remain under exclusive federal jurisdiction. United States v. Pelican applied the Indian Country Crimes Act to trust allotments. Reaffirming Celestine and Sutton, the court found it was, quote, not open to controversy, end quote, that restricted allotments continue, quote, under the jurisdiction and control of Congress for all governmental purposes relating to Indians, end quote. Pelican noted that federal authority to legislate for Indians is ample even within a state's jurisdiction. In other words, even if state law had attached, Congress could still apply its criminal laws to the area. Quote, the present question then is not one of power, but whether it can be said that the descriptive term Indian country is adequate to embrace these allotments. Pelican only raised an issue of statutory construction. Does Indian country include allotments? The court decided that restricted allotments are still Indian country. They retain the trust period during the trust period a distinctly Indian character. Pelican thus adopted the definition of Indian country that is coextensive with tribal territory. While they remain inalienable, allotments are also beyond the reach of state law. Therefore, restrictions on alienation determine both whether an allotment is sovereign and whether it is Indian country. The checkerboard federal criminal jurisdiction over various allotments within a former... let's skip something. The only real issue in Pelican was whether the court should allow a checkerboard federal criminal jurisdiction over various allotments within a former reservation. The court decided that as impractical as this may be, it is what Congress intended. So long as allotment is in trust or its alienability remains restricted, it is Indian country. Pelican forms the basis of subsection C of 18 USC 1151. You might talk a little bit about what these terms are, like alienability, etc., because the audience might not understand what that term is.
Well, this restricted property that all 5 tribes Indians have, if it's restricted and they're a restricted Indian, they can't sell it to anyone.
Okay.
That's
Well, do
that's
they have
what
to get
that's
permission,
saying.
or how does that
Do
work?
what now?
Do they have to get permission? How does that work?
Well, they have to get the federal government's permission.
Okay, so they go through the BIA before the
Yes.
land can change hands.
Yes.
Okay.
Yes.
So,
In other words, the federal government has that control, but the federal government does not own the land.
okay.
They just have control over a restricted Indian because they said a long time ago, if you're a restricted Indian, you're incompetent. You can't deal with your own land. We have
Okay.
to protect you. And they've done a shabby job of doing that.
Well, if you're ready, I'm going to move on down to
Sure.
the C qualification, and we'll go through that part, and then we will have.
Where are you
the
going now?
I'm going down. Now the author is going to speak about the C qualification and what the Supreme Court decision is that made
About
the
what
basis of
qualification?
it. 18 USC 1151 has A, B,
C.
and
C. You said C.
Yes.
Okay, thank you.
The other codified case from this period is United States versus Sandoval. Here, the court was dealing only with land that was outside of any state's jurisdiction. It noted that the Santa Clara Pueblo expressly had been set aside by the federal government and that the New Mexico Statehood Act accepts that Indian lands will be under the absolute jurisdiction and control of Congress. The court's opinion focused on whether the legal status of the Pueblo Indians had become too close to that of other citizens to allow Congress to legislate for them as Indians. The court determined that Congress has a right to determine for itself whether the guardianship which has been maintained over the Indians shall cease. In its most significant passage, Sandoval declared that the federal government has power to legislate for all dependent Indian communities in the United States. The dependent Indian communities test again was employed in United States v. McGowan, which together with Sandoval forms the basis of 18 U.S.C. 1151b. As discussed in the introduction to this article, McGowan involved a federal prosecution for the importation of liquor into Nevada's Reno Indian colony. The colony consisted of 28 acres that Congress had purchased for needy Indians in 1917. Obviously, this tiny plot could not stand as its own nation. No one expected that it would carry out its own civil and criminal administration, or that state laws would be ineffective within its borders. The Court of Appeals thus concluded that the Reno Indian Colony could not be Indian country. It assumed that an Indian country designation would mean the area was outside the reach of state law. The panel looked to a series of federal cases establishing that land can be removed from a state's jurisdiction only with the state's consent. One of the cases it quoted was the Supreme Court's decision in Surplus Trading, which reaffirmed that the state consent is a prerequisite to the creation of a jurisdictional enclave. Because Nevada had never ceded its authority over the colony, the court determined that it could not be Indian country. The Supreme Court reversed, finding that the Reno colony was indeed Indian country. The court made clear that it was modifying the definition of that term so that it would apply to an area where the state retained jurisdiction. McGowan noted that the words Indian country had been employed in the federal laws for many years without a new statutory delineation. Once again, the court declared that the term must be defined in the light of the changes which have taken place in our situation, end quote. In this case, the court emphasized that Congress had made the Reno colony the equivalent of a reservation, as the land had been, quote, validly set apart for the use of Indians as such under the superintendence of the federal government, end quote. The court thus found that the colony fell within the scope of Indian country statutes as a dependent Indian community. The McGowan opinion left no doubt that an Indian country finding does not retract the state's jurisdiction. The court affirmed that the federal government does not assert exclusive jurisdiction within the colony. Enactments of the federal government passed to protect and guard its Indian wards only affect the operation within the colony of such state laws as conflict with the federal enactments. The McGowan court based this conclusion on two prior decisions, Hallowell versus United States, the first Supreme Court decision to apply the Indian country label to an area under state law, and Surplus Trading Co. versus Cook, the same case which the Ninth Circuit had relied on for the proposition that a state's authority over its land and people can be taken away only with its consent. The rest is legislative history. In 1948, the compilers of the revised statutes codified the Donnelly, Pelican, Sandoval, and McGowan decisions as the definition of Indian country, and then it goes on to quote the definition of Indian country that we read earlier. So, this article is very interesting. It continues on, and if you're interested in this topic, I recommend that you go check it out. I want to remind the audience that we're taking questions right now, and I just saw that we have a question here. I'm going to go take a look at it real quick and see what it is. Well, if my computer would go. It says Jeshua Stacy says the tribe has no real sovereign rights if at any point they depend on the U.S. government. Okay, this is just an opinion. All right, thanks for the comment, and we are also taking questions, so if anybody has any questions, go for it. Hop into the YouTube chat. With that being covered, we haven't seen any cases. McGirt is still relating to the reservation status. We haven't seen any cases that are challenging on B or C as far as in Oklahoma yet. That is a possibility because right now that's the debate. at this point, we can go back to what the status of Murphy is right now as far as, let's see, where am I at? That's McGirt. The question that was asked by Justice Roberts. Here we go. Let's scroll down. Is this Murphy? Yes. Okay, let's scroll down here. December 4th, 2018, the solicitor, is that right? Yes. The parties, the Solicitor General and the Muskogee Creek Nation are directed, hold on, I messed up. Are directed to file supplemental briefs addressing the following two questions. So what we have here is the Supreme Court is asking all of the parties involved, or he's asking the Solicitor General, which represents the United States, the Muskogee Creek Nation, and the other parties to file an additional brief to answer these questions. The first question is whether any statute grants the state of Oklahoma jurisdiction over the prosecution of crimes committed by Indians in the area within the 1866 territorial boundaries of the Creek Nation, irrespective of the area's reservation status. And two, whether there are circumstances in which land qualifies as an Indian reservation, but nonetheless does not meet the definition of Indian country as set forth in 18 U.S.C. 1151A. The briefs, and then there's some qualifications on the briefs. So they're asking two questions there. The first question is can any of the parties show that there is any statute that's been passed that specifically gives a jurisdiction over to the state over the crimes committed by Indians within the Oklahoma jurisdiction, okay? And then two, the justices are asking, do any of the parties know of an instance where you could have a reservation status declared, but then there's the definition of Indian country can't be applied to that reservation through whatever means. If we go down,
And what answers did they get?
let's go down and we'll take a look here real quick. So first, let's look at this is the brief for the petitioner. So that's Mike Carpenter, and this with this
Hunter. Well, Hunter.
Now it's
Attorney
Sharp.
General's doing it.
Right. So these are the parties. Let's go down and see. I'm going to go and skip.
Wait
to-
just a second. Let's read these questions. Sometimes
Okay.
they manipulate
Yes,
them.
that's true. The questions presented. Now these should match up with the questions that we just read earlier.
They should.
1. Whether any statute grants the state of Oklahoma jurisdiction over the prosecution of crimes committed by Indians within the 1866. You want to come back on in, Angel, if you're ready.
Yep.
Angel's back.
Well,
She had to go do some
let's
new
just
stuff.
see what the Attorney General says.
Well, we're gonna double check. He says Oklahoma jurisdiction over the crimes of Indians, prosecution of crimes committed by Indians within the 1866 territorial boundaries of the Creek Nation, irrespective of the area's reservation status. Let's see, is that the same? Let's go. I'll back up. Yes, looks like it's a direct quote.
Should be.
2. Whether there are circumstances in which land qualifies as an Indian reservation, but nonetheless does not meet the definition of Indian country as set forth in 18 U.S.C. 1151A. Is there a specific area you want to address?
What was the Attorney General's answer?
I'm going to go down to the conclusion part.
Okay, fine.
If you're okay with that, we
I'm
won't
okay
look
with
through
it.
all of the entire document, but we can go down to the bottom and see what he says in conclusion. Yeah, there's 2. Let's go up till we get to 1. There's a lot of citing here. Did I miss it? There's the last. Indian reservation. So they're answering their first thing here says, or the second question, they're saying federal Indian reservations are Indian country under 18 U.S.C. 1151A. So The court directed the parties to address whether they are, and it says the answer is no. So the Attorney General is saying if it's an Indian reservation, the Attorney General of Oklahoma is saying if it's a reservation, then it is Indian country. No doubt they're not going to challenge that second question point. Let's go up and see if I can find what their answer to the first question is. I imagine, if I remember correctly, when I read this brief, that their argument is that there were courts in operation and that the jurisdictional responsibilities were transferred to certain state courts, and that is yeah, here we go. Petitioner summarizes the brief. Oklahoma has criminal, civil, and regulatory jurisdiction within the boundaries of the former Indian Territory. This court directed the parties to address whether any statute grants the state of Oklahoma jurisdiction over the prosecution of crimes committed by Indians within the 1866 territorial boundaries of the Creek Nation, irrespective to the area's reservation status. They say the answer is yes. It says 1. Statutes enacted in 1897, 1898, 1904, 1906, and 1907 conferred jurisdiction on Oklahoma to prosecute crimes within the 1866 boundaries of the Creek Nation, as well as the historical boundaries of the other 5 tribes. In 1897, the Congress conferred exclusive jurisdiction on the U.S. courts in Indian Territory. So what they're referencing there is the Congress created the Indian Territory courts to address cases within the Indian Territory, to try all criminal cases applied U.S. and Arkansas law irrespective of the defendant's race. Indian Department Appropriations Act of 1897, chapter yada yada. This ended disparate treatment in the application of substantive law and jurisdictional determinations on the basis of Indian status in eastern Oklahoma. So they're making an argument that says that Congress established the Indian Territory courts. And if we keep reading here, that jurisdictional responsibility was later transferred to Oklahoma courts.
So they answered the Supreme Court's question.
They're saying that because they created this Indian Territory court that they have jurisdiction over the area. That's not actually addressing that main question, though. The question was, is there a statute that gives you what was it? Let me quote it so I'm not going off the... Whether any statute grants the state of Oklahoma jurisdiction over the prosecution of crimes committed by Indians in the area within the 1866 territorial boundaries of the Creek Nation, irrespective of the area's reservation status. So they're saying that is there any... And the state AG is saying that when Congress created the Indian Territory courts, that's where the creation of those courts gave the state of Oklahoma authority over that jurisdiction.
Well, but the state of Oklahoma didn't exist.
Well, that's the counter argument is that...
Well, what happened to that law when the state of Oklahoma was created?
The Curtis Act of 1898 abolished tribal courts and rendered tribal law unenforceable. In 1904, Congress confirmed that Arkansas law extended... I'm going to make this a little bit bigger. Arkansas law extended to all persons and estates in Indian Territory, Indian freemen or otherwise. This is Oklahoma. And the Oklahoma Enabling Act, as originally enacted in 1906 and as amended in 1907, directed the transfer of all pending federal criminal cases to the newly created federal courts in Oklahoma, and directed all other cases to the newly created state courts, including cases involving major crimes. Accordingly, the laws of Oklahoma Territory and eventually the state of Oklahoma supplanted the Arkansas law that had applied to all persons irrespective of race, and the state courts became the successors of the territorial courts. So that's their argument is that the Enabling Act... Well, that's not an argument,
that's a fact.
Right, but they're saying that...
There's no argument about facts.
Yeah, the facts are, though, that what was transferred were the pending cases. There's nothing in the Enabling Act that specifically says that Oklahoma has that jurisdiction, though. You see what I mean? Anyway, that's their argument. Whether they're right or wrong, the Supreme Court will make their decision on that. Basically, the state AG's answer to was there a statute passed
yes.
is the Oklahoma Enabling Act gives us the right to do it. There's one little wrinkle with that, apart from what we're seeing in this brief. If you read the gentleman's article that I was speaking. Before the 1948 codification of Indian country, that is 18 USC 1151, right? Before that existed. The term Indian country has a history of being used by the United States, and even before the United States is a legal term. And there was a period in there where, if you remember when I was reading that section, he refers to states seceding their authority or having things in their constitution where they admit that they don't have jurisdiction over certain things, right? Does that sound familiar?
No.
Okay, let me go back and I will pull up this. My point of getting there is that the Oklahoma Constitution has a section in it that says, the people inhabiting the state do agree and declare that they forever disclaim all right and title in or to any unappropriated public lands lying within the boundaries thereof, and to all lands lying within said limits owned or held by any Indian tribe or nation, and that until the title to any such public land shall be extinguished by the United States, the same shall be and remain subject to the jurisdiction, disposal, and control of the United States. Land belonging to citizens of the United States residing without the limits of the state. And then they go on to talk about the taxes. The taxes should be the same, etc. No taxes shall be imposed by the state on lands or property belonging to or which may hereafter be purchased by the United States or reserved for its use. Can that be interpreted as them ceding jurisdiction over Indian lands? It says held by any Indian tribe or nation. How does that affect the argument that the state of Oklahoma's AG is making? He's saying we had courts that were functioning. Those jurisdictions, those cases from those courts were transferred to the state courts, but would take precedent
Until that title was extinguished.
Yes, but what I'm pointing out here is you had the Oklahoma Enabling Act. There's something that happened after the Oklahoma Enabling Act. What was it? The Oklahoma Constitution.
But there were other things that took place after the Enabling Act. The Enabling Act merely says Oklahoma has no jurisdiction over Indian country or Indian lands that are owned by the Indian tribe or an individual.
Well, the argument,
until that title is extinguished.
Right, but the argument that the state AG is making is that the Oklahoma Enabling Act transferred the cases from the Indian Territorial Court to Oklahoma courts, right?
Mm-hmm.
And that's where we get the jurisdiction. After that happened, the Oklahoma Constitution was passed, which says we don't have it anymore. We don't have jurisdiction over that. You see that if we interpret that part of the Constitution to say, the Oklahoma Constitution, to say that we don't have those jurisdiction over lands held by Indians or tribes or anything else, then even if the Enabling Act, they gained their jurisdiction by that, they gave it up when they passed the Constitution, right? Because the Constitution happened after the Enabling Act.
Well, the Enabling Act is not something Oklahoma passed. That was passed by the Congress.
But one of the arguments, or one of the ways Indian country was determined before the 1948 Indian Major Crimes Act was when a state cedes or gives up its jurisdiction over Indian lands.
Every state west of the Mississippi except for Colorado did that in their Constitution.
Yes, and there are Supreme Court cases that have since that time said that that's really irrelevant in the determination of Indian country. I'm not saying that it is, but there was a time when that was a thing, and it's hard to make a historical jurisdictional argument there, if you ask my opinion, because you have the Enabling Act, which is passed, and that's fine. You're saying Congress signed a statute, says we can get these courts. But then if your state ratifies a constitution after that where you give up that jurisdiction, how do you make that argument?
They only put in there that they were giving up that jurisdiction over land that was currently owned by an Indian tribe or an Indian.
Yes, it says.
And after that, then there were deeds from principal chiefs of the Creek Nation, fee simple deeds to creeks and also non-creeks, freedmen and white people.
But
is their property no good? Is it?
But how do you overcome that constitutional limitation? You have
it's severed whenever the chief signs a deed to somebody.
Yeah, but because the land changes hands doesn't change the Constitution of the Oklahoma.
Doesn't have to, but it changes the law.
how does it change the law? I don't.
It changes it from being no jurisdiction to jurisdiction by stroke
No.
of the pen.
The Oklahoma Constitution isn't assigning a jurisdiction. It's saying it's not our jurisdiction.
Until one of these things happens.
No, that's not in the Constitution.
What does it say in the Constitution? Until
It
the
says
state...
the people inhabiting the state
Uh-huh.
do agree and declare that they forever disclaim all right and title
Until...
in or to any unappropriated public lands within the boundaries thereof, and to all lands lying within said limits owned or held by any Indian, tribe, or nation.
Correct. When the Indian tribe or nation or Indian doesn't hold title to it, it's not included in that. Then it becomes state jurisdiction.
No, that's my question: is how does it get to that? Because the
Because there's
Constitution is saying
nowhere
they
else for
forever
it to
disclaim
go.
it. The Constitution is saying they forever disclaim it. Whether it changes
Only
hands
as
after
long
that,
as it's owned by an Indian tribe, whatever else the language is, or an Indian. As a matter of fact, that's been tested in court too.
So, well, that's my question on that.
Once the tribe deeds it to somebody else, for instance, a principal chief signed the deed for a freedman to land right here in Okmulgee, for instance. It's not Indian country any longer. It's the freedman's land.
Yeah, but that's my question.
Or if they signed a
how does
deed
that
to a non-Indian, it's not Indian country anymore or Indian land. It's their land.
Right, but that's the system that the state has been operating under, and the argument
And that's what
to that
that
is saying that the jurisdiction exists because of the enabling act.
then they're full of bull.
Hold on, we got a bunch of questions. Let me make sure I'm in questions.
It's not questions, it's comments.
Well,
Oh, okay, yeah.
tell me what they are. I may want to go out and get in my car and
All
go
right,
home.
no questions, no questions. Ask about Great Spirit. I don't know where we would find out about the Great Spirit from,
The Great
from
Spirit.
any of this stuff.
He-
So that's a
He
counter.
needed to have a bigger hand in writing this law, that's for sure.
Well, I don't know. Then he would be in Congress. So apart from the jurisdictional argument, do you want to go down the rabbit hole now of where are we at? The docket. Would you like to look at what Murphy's response to those questions was?
Go to the comments by the Chief Justice of the Supreme Court on fee simple deed.
You want to look at the transcript
Yeah,
from the
yeah.
oral arguments?
Yes. I heard him
let me,
say it, but
Let me dig it up. It'll take
It's
me.
in the transcript. I'm going to go to the potty while you do that.
Go ahead. Angel, is there anything I can catch you up on?
Are you guys on Murphy or McGirt or what?
We are still talking about Murphy, and I think I can get to the oral arguments. Let's go here. Also, if you guys have any questions, again, I mentioned it, you can go in our chat. You can go on Facebook, Twitter, hit us up, ask any questions you have while we have Judge Moore here. We can go through and try to give you our best educated guess on it. As you can, and I will say too, if you go through the article that I posted in the comments or in the information section, this is a topic, this Indian country definition, that has gone back and forth over the decades, and there are arguments on both sides and precedent on both sides. The article that I referenced before that we read the section from, in fact, that gentleman's thesis and his end statement is that the Supreme Court, as we see it in 1997, is getting this definition wrong, etc. So it's not something we're going to be able to give you a definitive answer on, but we can point you in the direction of some information. Let's go to oral arguments, transcriptions. How can I get that? Transcripts. Okay, here we go. So we want to go to 2018. We want to go to 171107. Yeah, I gotta go back in time.
So since Murphy's being replaced by McGirt, basically,
No.
it's not.
Everybody thought that Murphy was making, most people would say Murphy was making a mistake, even filing for certiorari, but the Supreme Court took it quickly.
And McGirt's been accepted by the Supreme Court, but it
Yes.
hasn't been set for argument.
Correct.
Well, the question in McGirt, and this is one of the things we went through, is whether the Oklahoma courts can continue to exercise criminal jurisdiction while Murphy is being decided.
Mhm.
So that
And Supreme Court's going to answer that question.
so
And then are they going to go back to answer Murphy? Or
They will answer Murphy too.
Okay.
I have some comments on that when you want them.
I want them now because that's what I'm interested in.
Here we
is
go.
When are
This
we
is what I
going
was
to
looking
hear
okay, here we go.
McGirt, and when are we going to hear?
Now you wanted to
question
hear
on
the
Murphy.
fee simple question.
I want it from the Chief Justice.
Let me see if I can remember where the heck that is. Do you remember if that's at the end?
It's in the middle. Well, it may have been toward the end because nobody answered the
Let's
question.
go all the way down. I'm gonna
But he asked it.
Go all the way down. Because I remember
It's
that
in there.
you mentioned that. Oh, here we go. How about this? Let's see if it's in this. I can pull a page number. EF fee. Okay, how about this? Let's try deed. Deeds. Let's try 4020. Tribal sovereignty. In just a second, it'll take me some time to pull
You just
up.
go ahead and take your time.
What it
We got a long
is.
time. They got a while before they're going to make a
And if
decision.
you guys want,
So what makes you think that the Supreme Court is going to, rather than hear McGirt instead, they're going to, like, I know the state filed its brief or its motion asking them to hold on McGirt until
Mhm.
they've answered Murphy. But where did the opinion come from when people were saying that, oh, McGirt is the case that they can answer and not have a split? For
I've never heard that.
you haven't heard that at all?
No. I think it's up there so the Chief Justice can get them both heard at the same time.
I think a little bit of media outlets were talking, saying that possibly since there was that they never really came out and said it was like a 4-4 split, they just kind of stopped with Murphy, right? And Gorsuch had not participated
Correct.
in Murphy, so then McGirt was accepted, and then that people were kind of thinking that maybe that would allow Gorsuch in, and he had previously heard jurisdictional boundary kind of cases, of course, because 10th Circuit he was on Murphy and he upheld it.
This problem with it goes back.
Here we go. There's a question. Chief Justice Roberts, let me get a little bigger. But does that take into account the significance of the fact that the Creek received the land in fee rather than in trust? Because once you say the reservation doesn't matter, well, maybe it doesn't matter if you in a trust relationship, but if you've already gotten a situation where it's ownership direct, then maybe the significance of what you can still actually do as not what particular powers they could exercise, but whether they could exercise any powers. Then the fact that you really don't have a reservation to start with, that is like the other reservations in the country. What is the significance of that distinction? Mr.
Okay.
Gershengorn. So we think, Your Honor, that strengthens our position. We said it in the briefs. The reason for that is it's crystal clear there was a reservation to start, and the fee patent was an additional boost. Remember, the fee patent is not fee simple. Now he's making.
No, it says fee simple.
He's saying here that
He's full of, he doesn't
the
know what
fee
he's talking
that they
about.
don't have fee simple.
I've looked at the deed.
Of course, they can't sell the land they can't alienate it. If they abandon the land or disappear as a tribe, it reverts to the United States. So it's not a fee patent in that. Justice Roberts. But that changed with respect to the allotments. Mr. Gershengorn. Yes, Your Honor. There is no doubt that the reason Congress the reason they broke up the communal land ownership and broke up fee patents was to allow that sort of increased sale. They needed to do that. But that doesn't change the fact that there was a reservation ahead of time. There was It was land set aside for use and residence of the tribe. Congress repeatedly referred to it as a reservation. It's noted in our brief in the 1866 treaty, the Creek Reservation. In the 1866 Cherokee Treaty, the Creek Reservation. In the 1873 statute, authorizes the secretary to negotiate a cession of Creek Reservation. Hold on, let me just finish. So there was a reservation ahead of time. That reservation was not disestablished. The Congress chose precisely the words that don't disestablish when enacted. And then Justice Roberts says, thank you, counsel.
These are my comments on what you just talked about. Congress doesn't have anything to do with treaties.
Right.
They don't make treaties. So all this language about Creek Reservation and treaties and things of that nature, a treaty doesn't mean a thing with respect to the Congress.
Right.
I agree with everybody. Congress creates a reservation, but Congress doesn't do a treaty, and the treaty that created the Creek land and Indian Territory was done prior to 1854 and started in the 1820s and 1830s and was finally culminated with a fee simple deed in 1854. That lawyer's just trying to win his case.
Let's see here. I want to find. So, Gershon Gorin is on behalf of the respondent, right? So that would be Murphy,
Must be.
or the warden.
No.
The respondent is the warden, right?
Yes.
Okay. So, now? We have been operating under the assumption, or what we believe is the facts, which is that the tribe had the fee simple deed. In fact, I have it stuck on the wall over there. Let me go grab it. Let me go grab this.
Yeah,
And this came from you.
Well.
So, what do you make of the assertion that it was not a fee simple deed, it was a fee patent? I want to show this to the audience. This says, you can't really see it, it's kind of out of focus, but that highlight portion says, instrument recites that in conformity to the provisions of a treaty concluded on February 14th, 1833 between the parties above named, the United States does give and grant unto the above tribe of Indians the following tract of land in fee simple.
That's
So
exactly right. That's not what this guy's trying to talk about.
Well, he says it's a patent, so who's telling the truth?
It's a fee simple deed.
Yes.
He's trying to make it something it isn't.
Yeah, so
And that helps
would you
his
say
side.
that Mr. Gershon Gorin is not telling the truth?
No, he's telling it the way he wants it to be.
Well, is a fee patent, what is the difference between a fee patent and a fee simple deed?
Patent deeds are given by sovereigns.
Okay.
And the sovereign gave a fee simple patent deed. The lawyer, he needs to come to Oklahoma and study land titles just a little bit.
And
all these lawyers do.
Let's talk a little bit about the land titles in Oklahoma.
Okay, but the main problem with this whole rigmarole is the Creek Nation got a fee simple deed. When the Creek chiefs gave it out to the allottees, they gave patent deeds.
Yes.
You see?
Yes.
And now those patent deeds have turned into fee simple deeds, haven't they? When the process of time and the creek restricted person dies, or many creeks got a deed that weren't restricted.
Right. So
it was a hodgepodge of mess because it was created by the United States Congress.
So a jurisdictional argument that the state would make, and this was my understanding before the Murphy case of what the jurisdictional argument for Oklahoma jurisdiction in the state was, is that in these instances, the deed for the land, the tribe owned the deed, the fee simple deed.
Originally, back in
that when
process of this 1834 treaty.
When they did allotment, the tribe itself broke those lands up, and so the deed that you got in allotment was from the chief of the tribe.
Correct. The federal government could not give them that deed.
Right, because they didn't own it.
Correct. Now we're getting somewhere.
So, I'm saying this is the state's argument for jurisdiction.
No, that's the law.
No.
That's the United States Constitution. That's why the Chief Justice wants to know about that.
So, and when it came out of Native American hands or Creek hands, then it becomes Oklahoma jurisdiction, right?
Unless it happens to be to an allottee and it's in trust with the United States government.
I have to get reassigned in a little bit, but I have one more question before I go.
Sure.
If McGirt is pending on Murphy, is there anything that is going to affect current cases in the courts right now and their outcomes?
All I can tell you is they're filing briefs and what have you on it in a lot of criminal cases now in the state of Oklahoma.
Mm-hmm.
They're in Okmulgee County. You can go down there and Judge Ramirez will tell you about them.
Okay.
And you can read what they put in their briefs. Some of them are coming from people in the penitentiary who have other people helping them.
Mm-hmm.
Well, that's part of why I was pointing out the A, B, and C of that, is because right now the Supreme Court is seeing the challenges on the A, right? There's also the B and the C, and if you look at those are way broader because what it looks like from my perspective is the 1948 Major Indian Crimes Act, right? The construction of the definition of Indian country, right, was kind of purposefully broad so for certain situations so that the federal government could claim jurisdiction in those situations, right? But now it's become a situation where people are because over time the Supreme Court's definition or association with tribal sovereignty and Indian country, right, has created a situation where they say if it is Indian country, then it cannot be a state jurisdiction, which is kind of like when I was reading the excerpts from the article, there were cases before that where you could have a state jurisdiction apply and a federal jurisdiction apply, and they're not, they don't
You can do that today.
get rid
You
of
rob
each
a
other.
bank in Okmulgee, Oklahoma, the state of Oklahoma can prosecute you and the federal can prosecute you.
Right.
They both send you to the pen.
So the situation that we have now where it's like if it's determined to be Indian country, then these convictions that the state had will get overturned because the right
That's
body
correct.
didn't have it. That's the modern interpretation of Indian country, right? Whereas there were even at the time of 1948, that's one of the things that the gentleman's article points out, and before there was a situation where it could be Indian country and state laws still apply. You see what I mean? It's the modern interpretation of the definition of that word.
The Supreme
Or
Court,
that designation
the
of
Supreme
jurisdiction.
Court will work on it and they will come up with a resolution. And I don't think the resolution is going to be liked by everybody.
Well, it's hard to make predictions about the future in this particular case because nobody knows. But
I can make you a prediction.
What is your prediction?
The Supreme Court will make a decision.
Will they do it this year?
I don't know.
I think it's going to be difficult because of all of everything else that's going
It
on.
depends upon the Chief Justice.
Mm.
The Chief Justice controls what leaves his court.
In
How
fact,
old is he?
I don't know.
Well, he's in his 50s, isn't he, Jared? He's a young Chief Justice.
I'd have to pull it up, but yeah, he's not super old.
He's going to be up there for a long time.
Mm-hmm.
He controls
Let's
that
look
court. That's his court.
here. Let's see. Okay, so
I'm gonna bounce.
all right, thanks for coming in. Appreciate it.
And there's been no questions so far. So
Okay, yeah, we haven't got really any here.
Well, that's relief.
The Supreme Court calendar has not been updated for the let's see, I think it's the March, or I think it's May. There's 2 more sessions that they could possibly schedule oral arguments for
They'll
cases.
schedule it when the chief wants it done.
So they haven't scheduled those. But they have the impeachment hearing and et cetera, going on. So we'll see if they can squeeze it in.
They do not have to hurry.
The relisting, how often does that happen? Because it seems to me that it's kind of rare that they would relist it for oral arguments again, not get it solved in a term.
Well, my answer to that is they're not going to uphold it. That's my answer. The
They're not
easiest,
going to uphold the lower court's decision.
correct.
So you think that they're going to overturn
I don't think they're going to uphold it.
How
And
would
if they
they-
had wanted to uphold it, they would have just denied cert or not done anything about it, period, or agreed with the 10th. The 10th Circuit only had 3 justices participating out of their 15. And for some reason, the Chief Justice of the 10th didn't want the other input from the others. That could have changed the whole thing, couldn't it, in Denver?
Well, do you think that the reason that it's been held over and they couldn't come to an agreement, even though they don't agree with the lower court's decision, because your supposition is that they wouldn't have taken cert on the case if they were going to uphold the lower court's decision?
No,
That's what
I'm
you're
not saying that at all.
Okay.
I'm saying they didn't make a decision, and now I feel like they're not going to uphold the lower court.
Okay.
That's what I feel now.
So, because
and it's because of the Chief Justice's question.
do you think it's because they're trying to build the framework for how they're going to address this jurisdictional conflict?
I think that
You would think if they overturn the lower court's ruling, that in their decision they would have to
yes,
outline how this is going to work.
You know, I served on the Supreme Court project for 10 or 15 years. We
Mm-hmm.
reviewed every case, Indian tribal case, that went to the Supreme Court. Every time a Indian case went to the Supreme Court of the United States that was not brought by the Indians,
Mm-hmm.
the results are bad.
Right.
And
Well-
this was not bought by Indians, it was brought by lawyers for a criminal defendant.
Well, but the tribe did sign on that side. The tribe did sign on that
They
jurisdiction.
did, but Creek Nation's the only tribe that did.
That's true. Well, but you could also say that the reason is because it's the question before the court specifically is about the Creek Nation. It's not about Cherokee Nation boundaries or any other nation's boundaries. The question before the
But
court.
whatever happens is going to apply to every one of the 5 tribes.
Well, and then again, we would have to go well.
And it might apply to some other tribes that have reservations in Oklahoma. That's another big bugaboo that's out there nobody's even thought about.
There's something I want to parse on this, right?
Mm-hmm.
So, the Supreme Court would be deciding in the question before them, right? So we're saying that they would overturn the lower court's decision. So the lower court's decision is that it is a reservation, and thus the prosecution is no good. So if we're saying, and the question before the Supreme Court is whether the 1866 territorial boundaries of the Creek Nation within the former Indian Territory of eastern Oklahoma constitute an Indian reservation today under 18 U.S.C. 1151. That's the question before them is it a 1866 boundaries, are they a reservation? So for them to overturn the lower courts,
It's real easy.
they would have to say it's not a reservation.
It's real easy. The Congress has never established it as a reservation.
Right, that's true.
There's no law written. Treaties are not congressional acts. They are acts between the president and whoever he's treating with, and they don't require the United States Congress's approval. They just require a majority of the senators who are present when it's presented in their gallery.
Right. So,
A lot different.
Well, if we're going down that road, how would you address the claims that are in the briefs of Congress mentioning the Creek Reservation and so on?
That was in a treaty, wasn't it?
No. They're saying that
Well, it
in
doesn't make any
subsequent
difference.
statutes,
They can't create a reservation out of land they don't own.
Well, yes, that's true. So,
I can't just decide, well, I'm going to take over your house.
well, if you're the federal government, you might be able to.
If they follow the Constitution, they can.
Right.
But they'll have to build a prison there, or they'll have to build a federal building there,
Right.
or they'll have to build a military installation on where your house is.
Or a wall. They have to build a wall.
Well, it's not going to do them any good in Okmulgee. They can
Well,
do that too.
well, if the tribe gets the
if they
jurisdiction,
decide
they
to
might
build
decide they wanna
a
put a
wall,
wall.
if the U.S. decides to build a wall, the wall's going up, boys.
Yeah. All right. So let me see. I'm going to go through these links really quick and see if there's anything that I missed that I was going to talk about. I don't think that there is anything else. If you have a question that you'd like to get in before we shut down, go ahead and send it our way. Oh, now this was something. What was this from? No, this was, we mentioned that in the brief. That's the Constitution. We did that. That's the review case. The Murphy case has not, just as a wrap up, the Murphy case has not been scheduled for oral arguments.
I don't know about that.
I just checked it.
Well,
We just went and looked.
If you've looked at it, that's fine.
Here's a calendar list. We can go to February 24th. We'll look at it. Let's see what's on here. No Murphy case there. So this is the most recent scheduling. Nothing there.
The Chief Justice will put it on wherever he wants it.
McGirt case also has not been scheduled for oral arguments yet. Probably would look to see that in the earliest in the fall because they're still in the cert process.
My thoughts are that McGirt's not going to go before Murphy.
One more thing I wanted to look. Do you want to, while we're here, look at the McGirt filing, what McGirt filed?
No, I don't.
So we can see what his argument in his specific case would be? Or is that something that and here it is. This case involves state court action. This is his conclusion from his brief. This case involves state court actions without subject matter jurisdiction and doubtful determination. Let me make it a little bit bigger. That text is small. Doubtful determination of important questions of state power over Indian affairs in Indian country within the Muskogee Creek Nation of Oklahoma. It affects the fairness, integrity, and public reputation of judicial proceedings and the abuse of the state's authority. Therefore, this petition for certiorari should be granted and the case reversed and remanded to state court to dismiss the state convictions as void ab initio and release the petitioner forthwith, executed under penalty of perjury, and etc., etc. So, is there any comment you'd like to make about what his claim there is? No? Okay.
Well, that's just his conclusion.
Yes, but
there's other issues nobody ever even talks about with respect to these cases. If the Supreme Court says state didn't have jurisdiction, they're going to empty the jailhouse.
Yes, sir. Yes.
And when they do that, the feds can't try them all because they have no evidence. Everybody's dead.
Yes.
Everybody's dead.
And even in situations where everybody's alive, oftentimes the evidence was not collected by any tribal authority or a federal authority.
Correct. That's right.
So that's a problem.
But I have something else I wanted to talk to you about just briefly.
Sure.
Reservations are created by acts of Congress.
Yes.
Not by acts of the president, not by executive orders, and not by stroke of one man's hand.
Mm-hmm.
In the 1880s, the United States Congress didn't like the idea that they were out of the loop on treaties with Indians. There's a lot of jealousy between the House of Representatives and the United States Senate. I don't know if you know that or not. There's also a lot of jealousy between the House of Representatives and the Chief Executive of the United States on occasions. So in 1880, they passed a law that said no more treaties with Indian tribes. Now, that was long after the Creek Nation had the deed from the President of the United States pursuant to a treaty, okay?
Okay.
In the Laura case, which was before the United States Supreme Court within the last 6 or 8 years, that particular matter came up in the dictum in the Supreme Court's opinion, and that dictum came from Judge Clarence Thomas. Judge Thomas said the repeal or change of the United States Constitution by an act of the Congress is constitutionally suspect. You know why? The people have to approve changes to the Constitution.
Right.
And they've gotten away with that over 130 years.
Okay.
40 years now.
I'm trying to pull up what you're referring to. It could have been the 1787 provided the Senate of the United States shall have the power to make treaties and to appoint ambassadors and judges of the Supreme Court.
It's in the Constitution. It's in the Constitution of the United States. I'll tell you what section it is. Just a minute. Blah blah blah.
Treaty commitments of the United States are of two kinds, as Justice Marshall
Article
wrote.
6 of the Constitution.
Well, tell me if this is related, because I'm just trying to pull things up to relate to what you're talking about. Treaty commitments of the United States are of two kinds, as Justice Marshall wrote in 1829. A treaty is, in its nature, a contract between two nations, not a legislative act. It does not generally affect of itself the object to be accomplished, especially so far in its operation is infraterritorial, but is carried into execution by the sovereign power of the respective parties. Sorry. I made it, trying to make it bigger and I got last. Here we go. In the United States, a different accomplished especially as far as operation infraterritorial, but is carried into execution by the sovereign power of the respected parties to the instrument. In the United States, a different principle is established. Our Constitution declares a treaty to be the law of the land. It is, consequently, to be regarded in courts of justice as equivalent to an act of the legislature whenever it operates of itself without the aid of any legislative provision. But when the terms of the stipulation import a contract, when either of the parties engages to perform a particular act, the treaty addresses itself to the political, not the judicial department, and the legislature must execute the contract before it can become a rule for the court. And then we'll go down. I'm assuming they're going to go through and talk about which justice was were you speaking of that made that decision? Laura.
It was Justice Thomas.
Let's see. Hopkirk versus Bell, Foster and Nielsen.
Treaties in Congress.
Let's keep going down. Oh, is this what you're speaking of? Congressional repeal of treaties?
No, they said that there could be no more treaties with Indian tribes, Indian nations. They passed a law.
Let's keep going down here.
We'll see if you can find it. Just keep going.
Missouri versus Holland. Missouri versus Holland. Do 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 do. 18 termination of treaties by notice. Discrimination treaty, status of a treaty, a political question. Oh,
Indian
Justice
treaties.
Marshall.
Go to Indian treaties right there.
Did I go past it?
No, you're coming up on it.
Here we go. In early cases of Cherokee Nation versus Georgia and Worcester versus Georgia, the court, speaking by Chief Justice Marshall, held first that the Cherokee Nation was not...
You can go down to the second paragraph. That's where your answer's going to be.
All right.
Later cases.
Later cases established that the power to make treaties with the Indian tribes was coextensive with the power to make treaties with foreign nations, that the states were incompetent to interfere with rights created by such treaties,
Next
as
one
long
down.
as the United States recognized the character of a tribe, its members were under the protection of treaties and of laws of Congress, and their property immune from taxation by a state, that a stipulation in an Indian treaty that laws forbidding the introduction of liquors into Indian territory was operative without legislation and binding on the courts, although the territory was within an organized county of a state, and that an act of Congress, contrary to a prior Indian treaty, repealed it.
Go to the next one. Now there's
Today, the subject of Indian treaties is a closed account in the Constitutional Law Ledger by a writer inserted in the Indian Appropriation Act of March 3, 1871. It was provided that hereafter no Indian nation or tribe within the territory of the United States shall be acknowledged or recognized as an independent nation, tribe, or power with whom the United States may contract by treaty. Provided, further, that nothing herein contained shall be construed to invalidate or impair the obligation of any treaty heretofore lawfully made and ratified by any such Indian nation or tribe. Subsequently, the power of Congress to withdraw or modify tribal rights previously granted by treaty has been invariably upheld. Statutes modifying rights of members in tribal lands, granting a right-of-way for a railroad through land ceded by treaty to an Indian tribe, or extending the application of revenue laws respecting liquor and tobacco over Indian territories, despite an earlier treaty exemption, have been sustained. When, on the other hand, definite property rights have been conferred upon individual Native Americans, whether by treaty or under act of Congress, they are protected by the Constitution to the same extent and in the same way as the private rights of other residents or citizens of the United States. Hence, the court held that certain Indian allottees, under an agreement according to which, in part consideration of their relinquishment of all claim to tribal property, they were to receive in severalty allotments of lands that were to be non-taxable for a specific period, acquired vested rights of exemption from state taxation that were protected by the Fifth Amendment against abrogation by Congress.
Go down and see if there's any citation of Laura on that man's stuff.
I don't think
here.
it goes that far.
Well, that's been
these
a
are all
new
the
case. Take it
citations.
easy. Take it. Go slow.
Well, these
go
are.
slow.
I have
can't
to
read
look at the
that.
section to pull.
Go on down. Go down.
Thing. You want
Footnotes.
437?
Read the footnotes.
Well,
Let's
there's
look at the
400 of
footnotes.
them. Which one?
That's go down.
Which
Look at the
footnote do you want to
footnotes.
look at?
Footnotes.
Which one?
Go to the list. No, you went too fast. Start it now. Go down them right there, and let's see if we find the Laura case.
Foster, Nelson, Sanchez, Oregon.
Take it easy.
No.
Easy. Don't go so fast.
Well, I'm reading.
Well, I'm trying to read as I go.
Lindholm, Colovat, Goloy, Riggs, Terrace versus Tom. Let me start at the bottom because it's more likely to be at the bottom than the top. Farron, Treaties of
Well,
Law.
you're in middle of the. Keep going. You're in the. Just keep going. You're doing fine.
Foster, Nelson. I don't think it's that we reference Laura here because he does. It would go on past as Laura was
Well,
after.
then they
that.
didn't do good research.
Well,
on
they're
it.
not. This article isn't about specifically what we're talking about.
Well, they had a clause on Indian treaties.
It would be in this area here.
Just keep going. You're doing fine. Keep going.
Crandall. How about if I just look up Laura?
No,
You know how
just
to
keep
spell
going.
it?
I want to see if it's here. Then you can look up Laura. Okay, look
No.
up Laura.
How do you spell it?
Laur.
Laur.
U.S. versus Laura
U.S.
is up
US
north.
versus Laura.
Is
E.L.
Pardon?
Is it Laur?
Laur. E.L. or A.L. I'm not sure.
Let's try A.L. Jose Laurel.
No.
Okay, let me try the other one. No, it just went in there.
See what that one is.
This is. I don't think this is related.
That's
It's in
not it.
Manila. It's the Supreme Court of Manila.
Laurl. Try that. Laurl.
Let me try U.S. Supreme Court.
Laural. Let's see what that says.
U.S. versus Laurel. Let's look at this.
What year was that?
1998.
Yeah, you're doing good there. Wait. Go up this a little bit. That's not a Supreme Court case.
It's not?
Well, it's Flam, circuit judge.
Court of Appeals.
We got to go to the Supreme Court.
All right, let's go back. No. Does it have a case number on that?
No, I don't have it, but
I was just saying that post. Well, we're Mount Laurel Doctrine? No. I'm not seeing it.
put in there just, it was a traffic violation case. It had to do with dual sovereigns punishing somebody. It's in the hollow point, in the pocket part, in Canby's book.
Let's see here. How about, let me see here. Justice Marshall was
No, that's not it.
in that one. Well, we're off the track here. Let me try a different tactic. Court. Dual solve. Gamble. Marshall.
Keep going, you're doing good.
Well, shoot. I'm not seeing.
They're getting to it right there. It's dual jeopardy, double jeopardy.
Let's click into one of those and see if there's a way to get to that. Let's go to this dual sovereignty doctrine.
Well, it's double jeopardy, really, is what it is. There's one of those cases on it.
Health versus Alabama.
That ain't gonna help.
Nope. Let's go back.
They got crappy laws come out of Alabama.
Let's see here. Let's see here. Not that.
It's dual punishments, dual sovereign's punishment.
Let me look
Double
quick
jeopardy.
through here.
That's it.
Would it be in tribal sovereignty? Was it a tribal case?
No, well, the tribe convicted him, and then the feds convicted him, and he had a first-year law student as his lawyer, and they appealed it. It went up to the Supreme Court.
Gamble.
It was up in the north, someplace up there.
Well, don't know how to spell laurels.
Double jeopardy is what it's about.
Okay. How about this?
Just
Dual
put double
sovereign.
jeopardy, double jeopardy, double jeopardy. Supreme Court on double jeopardy.
Supreme Court rules. Let's go here. Or wait.
No, dual sovereignty has nothing to do with it. It has to do with double jeopardy. Got to get away
Right
from
here,
that
that's
sovereignty stuff.
Double
What is
jeopardy
double
clause.
jeopardy? Double jeopardy.
Hold on. Just hold on. You're not reading the. Let's see here. Oh, God, geez, Louise. I want to look at that. Get out of here. Same offense, Alito, Gamble. This
Double
is
jeopardy
Gamble.
is what it is.
Yeah, I got double jeopardy on there.
Okay.
Let me look and see. Let me go into this Gamble because it keeps bringing up Gamble. Maybe that was after the day, but
What
they
date
might
was
mention.
Gamble? It's not the case. Anyway.
Yeah, but they might mention the
They
case
could.
you're talking about as part of the history of the
If they mention the Laura case, then click on it.
Alito, Clarence Thomas, Bakers, Gamble. Rockburter, Kate Hughes versus Dixon. When did? Do you know when what year the case was from?
Oh, it would have been 10 years ago or so.
So in 2000s?
No, it's probably about 2000. That's 20 years ago. 2005, something around in that period, 2006.
Multiple punishment.
United States versus Laura. Yeah, let me get my phone out, and I can probably Google it and get it quicker than all this other crap.
Oh, LARA?
Yeah,
Here we go. LARA.
2004. Okay, you found it. Now go on down there and see if you can get to the part where Thomas.
And then the Major Crimes Act. What am I looking for?
Well, the appeal, the decision of the court.
Arguments. You want to look at the arguments?
No, I want to look at what
Opinion
the
of the
Supreme
court.
Court wrote. There, you.
Justice
now you're
Stephen
cooking.
Breyer delivered opinion in the court April 19, 2004. Breyer believed that the question the court needed to answer was whether Congress had the authority to relax
Okay,
restrictions.
keep going until you get to Justice Thomas's comments. He may have been in a...
Stevens Thomas. Justice
right there,
Clarence
stop.
Thomas wrote a concurring opinion stating that it was time to re-examine the entire concept of tribal sovereignty. He noted that doubtful precedents stated that Congress, and not another part of the government, had the power to regulate everything that a tribe could or could not do, which renders tribal sovereignty a nullity. Thomas did not believe that Congress has the constitutional authority to set the metes and bounds of tribal sovereignty. He noted that such authority
There it
was
is, right
not
there.
in the Indian Treaty Clause nor the Indian Commerce Clause. In his view, the tribes either are or are not separate sovereigns, and our federal Indian law cases untenably hold both positions simultaneously. Thomas further questioned the law, ending the practice of making treaties with the tribes, noting that this was the one clear constitutional provision that provides for dealing with other sovereigns. Thomas noted that a delegation of prosecutorial power is always to an executive branch, and that the tribes are not part of any executive branch of the federal government. Therefore, the case hinges on the tribes' inherent sovereignty, and based on precedent, the tribes possess that power.
Correct.
So his argument is
The
we
Congress didn't have the authority to take that power away. It's in the Constitution.
well, and also the tribes are recognized in sovereigns and treaties.
And that's what they want to be.
The United States Constitution recognizes
Correct.
treaties.
Absolutely.
The prosecutorial power of tribes comes from their inherent sovereignty.
Correct.
And so that it cannot be. So how would that address the
They
dual
wrote
jurisdictional
they
situation?
wrote the Constitution of the Creek Nation wrong. They put in the Constitution of the Creek Nation that they needed to put in there organized under their inherent sovereignty, not under the powers of the United States.
Right, but I'm just talking about the jurisdictional argument, though. If you're holding Justice Thomas' position, okay?
Here's what his position is. The Congress, the House of Representatives, I've read this, the House of Representatives was jealous of the Senate and the President making treaties, and they wanted to stop it, so that all of that stuff had to go through the Congress, i.e. the Indian Civil Rights Act and all that stuff, okay?
All right.
And when they held that, that's what Clarence Thomas is saying is constitutionally suspect. They can't change the Constitution by an act of Congress.
Right. Yeah. No,
It's simple. It's elemental
Right.
stuff. Just like this is elemental stuff.
But I'm not trying to understand. I understand Justice Thomas what he's saying. What I'm saying is, in this particular Murphy case, he's saying that the prosecutorial powers come from the executive branch,
Correct.
and on the tribal side, their inherent tribal sovereignty.
Correct.
That would appear to be an argument that is in support of the lower court's opinion, not the
No.
upper.
The lower court did something they didn't have the authority to do. They are changing the deed that the Creek Nation got back in 1854. You got a copy. You look at
No,
what
I
did it say?
Yeah, but my point is that what he's saying is that the jurisdiction, the tribal jurisdiction, comes from the inherent sovereignty of the tribe.
But the tribe's jurisdiction is not what you're talking about. The tribe isn't going to have jurisdiction to prosecute anybody in Murphy.
No, that's what the question is if it's deemed a reservation. Now this is in
The tribe
court.
doesn't want that to happen, or it's going to be a damn.
Well, they're filing the briefs on the side that
It's
they
going
do want it to happen.
It's going to be a horribly expensive thing for any Indian
Well,
tribe to undertake. They don't understand that.
That's up to them.
Well, there goes their permanent fund.
My purpose of what I'm saying to you is that Justice Thomas's opinion that you're referencing is saying that because treaties are recognized in the United States Constitution, in his opinion, that is where the prosecutorial authority for tribal jurisdiction exists, not the 1948 statute or any other qualification of Indian country.
Correct.
And at
So
what
it's
point
not-
did the tribe cede their sovereignty
They
or their
lost it
jurisdiction.
when they deeded property away from the tribe.
But there's nothing in those transfer of deeds or anything that gives up tribal sovereignty. There's not a waiver
You
of
don't have
sovereign
you don't
immunity
have
or anything else.
you don't have the power of a sovereign over land you don't own.
Yeah, but you don't when the United States sells land that they have that is public lands to individuals or leases it out to individuals, they don't lose their jurisdiction.
They're the United States.
And if you are just in Justice Thomas's
By
position,
the same token,
they're the same.
I can make an argument that Napoleon sold the Louisiana Purchase to us, and they shouldn't have because it belonged to Indians.
But that was done within a treaty.
Correct.
That's my point.
But no Indians involved.
No, but that's my point is the tribe got the land through a treaty. Right? The land
They got the land that's mentioned in a treaty which was worked out between the United States and the Creek Nation.
Yes, a treaty.
Then the deed was executed by the...
Right. That part, Justice Thomas says that's okay.
That's correct.
The part that he has a problem with, if you're in that mindset,
Is that they quit doing it.
is that the tribe later signed the deeds over an allotment, and then those lands went to other people that weren't natives. That part wasn't done in a treaty. There wasn't no treaty between the person who
But
bought the
the
land.
treaty gave the Creek Nation the right to sell and do as they pleased with the land.
Yes, but that
That didn't change.
But that doesn't eliminate their sovereignty or their jurisdiction.
That's why in the Enabling Act it says, as long as it's owned by an Indian or a tribe, it's the state has no jurisdiction.
No. That was the Oklahoma Constitution, not the
That's in
Enabling
the
Act.
Enabling Act.
The
Well, in the Constitution too. It's in both of them.
So, but that's my point is when the federal government does the same operation, it doesn't lose jurisdiction.
Well,
The only
as
way
I
you-
said, the federal government has jurisdiction over bank robbers, and state has it too.
Justice Thomas's his mindset on the
he
jurisdiction
may be a problem with it.
No, but look, if you're looking at this, what he's saying is that the only way the jurisdiction can change hands is through a treaty, because the executive has the prosecutorial authority in the government, and the executive is the only one who can make a treaty.
And once that treaty is made, and the land leaves that particular sovereign,
he ain't saying that. He's not saying that.
Once if Oklahoma deeds they do deed property to the federal
We're
government.
not
they lose
talking about
jurisdiction.
Oklahoma. Oklahoma gets its prosecutorial authority from the federal government.
No,
It's
this is
below
from
the federal government.
From the Constitution.
Right, their constitution, which says we don't want any Indian
and
stuff.
the Creek Nation gets their prosecutorial authority from their Constitution, and what does it say?
No,
Who can they prosecute?
no. Well, now you're talking.
They have
about,
a judicial
now
branch.
you're talking about something that's not Justice Thomas's opinion.
But who can the Creek Nation prosecute under their Constitution?
We are looking at Laura, and what Justice Thomas.
Can the Creek Nation prosecute under the same facts as the Laura case? Can they prosecute somebody just the same as Laura? Creek Nation.
Can they?
Yes.
It would depend on what their laws are.
And it depends upon what the crime was.
Well, I mean, yes, they would have to.
Really, this whole thing is caused because the Creek Nation never did notify the United States of America that we don't want the death penalty for murder cases in the Creek Nation.
I think the whole thing is caused by what Justice Thomas, what Justice Thomas is saying is that right now the federal government has it both ways. We have statutes that were passed by Congress defining tribal or jurisdiction or federal jurisdiction in these situations as one thing, and then we have the treaties which define it as this other thing. And which one is it? And he says that he's more inclined for the treaties because the prosecutorial power is in the executive branch, and on the tribal side, their sovereignty is what gives them their prosecutorial authority. So if you were going to guess right now which way Justice Thomas would go,
Who knows?
well, I'm saying just based on his
think
findings
he's gonna
here
go- he's
in the
gonna-
Laura case, you would say Justice Thomas has a treaty where the tribe got the
And
land.
the treaty said it's fee simple.
That's right. So they got it.
Well, but then they've conveyed it away, which they can
That
do.
part doesn't have anything to do with the jurisdiction.
No, it does,
On his
Jared.
point.
They conveyed away the western half of Oklahoma, and they don't have jurisdiction
that
out
argument
there.
is based on the classification of 1948 law. That
No,
argument-
that law, the law
Oklahoma
that it's
has-
based on is 1854.
Oklahoma in the Constitution ceded the jurisdiction in the Constitution.
No, they just didn't assume it until it's all away from the tribe.
Yeah, but whenever they assumed it or not, they ceded it, and that's all. That's what they look at in the historical context.
Well, we'll see.
It's just like if the tribe made a treaty with the state of Oklahoma, and
Are
said,
we still live on this thing?
"Yeah, yeah, absolutely."
Well,
We had 7 viewers. Let's see if there's any questions. So that my point is, and this is a thorny thing, but we're talking about Justice Thomas's statements in the lower case in that decision.
What he's saying in that decision is what the Congress did was unconstitutional.
Right. And most
Plain and simple. And it is.
Yeah, it's violation of treaties.
No, it's a violation of the United States Constitution.
Yes, because the Constitution says treaties are the law of the land.
No, it says that the Indian tribes can still treat with the United States without the approval of the Congress.
Yes, he is.
And
saying,
what the Creek Nation and these other 5 tribes let happen is they let the Bureau come in and write them a constitution. They should have written their own constitution.
Yeah, but that's not an argument. Nobody's making that argument. They can't.
No, the state doesn't care about that argument.
Yeah, but because that argument will have to go through a tribal court first to say the constitutionality of the Creek Nation Constitution. That's not, you can't decide the constitutionality of the Creek Nation Constitution in an Oklahoma court.
That's correct.
It can't be done. So,
But you can't. I doubt they can decide it in the Creek court.
well, wherever it would be cited, this doesn't have anything to do with what we're talking about. Is my point.
Yeah.
The-
Well,
if
what are
you're-
some of the questions people are asking?
Oh, we don't actually have any questions in there, so I think we're going to wrap up for today.
I'm
we
sorry.
will. We were going to. I would like to have you come in again on another deep dive, and anybody out there that stayed with us this long down this rabbit hole, we're going to probably try to do one in the coming weeks after we go over some other types of comments. But we'd like to do one on taxation within the tribal jurisdiction. Would be interesting because it's related to this directly.
No treaties on that.
We have also. I would
But
like.
there's a compact.
What was the other? Oh, the compact. We'd like
Compact,
to do
yeah.
a deep dive on the compact.
You see what they've done? They've just
Well, let's not do it now. We got. Let's wait and do it. We got to do it.
remember.
Stay on top.
There's a big play on words with these compacts. They're
What's-
really a treaty.
Yes. So we will
But
go.
why do they call them a compact?
That's an interesting question.
Why do they call a stud fee a treaty?
That's a good question.
They do.
So we'll go down that rabbit hole on another deep dive. I want to thank
It's
everybody.
It's fun for me. I hope the Creek Nation enjoys
Well,
it.
I think it's interesting to citizens, and it will be an interesting program to continue. Just because some of these issues, there is such a long history and a debate for and against, and the outcomes of the decisions of the Supreme Court and tribal sovereignty affect the whole structure of
That's
reality in these areas.
But remember, as time passes, things change.
Absolutely, and from doing research on this case, the opinions and the legal justifications and everything for all of these things has changed. That it just seems to cycle through. The tribes have power and the tribes don't have power, and the federal government can do this and they can't do this. And how are we going to solve? There's always a case where there's a murder or someone violated a state law or something, and somehow there's a problem with it, and we've got to either legislate or there has to be some decision that the Supreme Court has to part some details. So it's still a work in progress, all of everything. So I want to thank everybody for coming out, and this has been Deep Dive, and we will check in with you again. Next week, I think we're going to try to do a program on ICWA and have an expert in on that, and then the week after that, we might get back to the compact. We might get back to the taxation issue, and we're going to have some other people come in. So thanks for watching. Appreciate you guys, and let me get my thing ready. And we will see you guys next time on Deep Dive.